Thank you so much. It is wonderful to see such a robust audience here for this webinar to talk about the Pell reinstatement regulations and the prison education programs. We have people joining from Guam and Nevada and Virginia and the Federal Bureau of Prisons and Illinois and a lot of other parts of the country represented. So thank you all so much for taking the time. I'm Margaret Zerga. I'm the director of VERA's Unlocking Potential initiative. And if we can go to the next slide, I'll give you a little bit of a preview of our plan for today. So we're going to give you a little bit of background on the VERA Institute of Justice and Second Chance Pell. We will talk about the federal Pell reinstatement regulations for prison education programs, which include both prisons, jails, and juvenile facilities. We'll give you some updates on how this intersects with some of the financial aid changes that have occurred recently. We have a bunch of resources for you, and then we'll leave a lot of time for Q&A with our partners at the U.S. Department of Education. Thank you all so much for those of you who sent in questions in advance. We've really used those to craft the time today. We are recording the webinar, and we'll be sharing the recording and the slides with everyone who has registered after, so you'll have access to the links and the other details after the event. For those of you who are not familiar with the VERA Institute of Justice, we're a national research and policy organization focused on fighting mass criminalization and creating anti-racist reparative justice systems. We work closely with government partners and community advocates and use the power of evidence to drive effective policies and practices. For the past 10 years, we've been working to expand access to college and prison, an effort rooted in our commitment to the human dignity of people who are incarcerated. So I want to offer a little bit of context for the policy changes we're talking about today. As many of you know, in 1994, people in prison lost access to Pell Grant eligibility, and we saw the availability of college programs dry up nearly overnight. Fast forward to 2016, and the U.S. Department of Education launched Second Chance Pell as a pilot program to allow a select number of colleges to access incarcerated students' Pell eligibility for the first time since 1994. There was huge interest from corrections, from colleges, and from students. And right now there's 200 colleges participating in the Second Chance Pell pilot. VERA is the national technical assistance provider for this network, and we are privileged to work closely with the colleges, corrections departments, and accreditors on this important area of work. In the first 5 years of Second Chance Pell, over 28,000 students have earned 9,000 post-secondary credentials. This includes certificates, diplomas, associate's degrees, and bachelor's degrees. So our field is building on a lot of experience administering federal Pell Grants in prison that will set us up for success with this new opportunity with Pell reinstatement. So for those of you who are not involved on the financial aid side, you might be wondering why Pell Grants matter so much. The Pell Grant is the largest federal grant program offered to undergraduates and is designed to assist students from low-income households. A federal Pell Grant, unlike a loan, does not have to be repaid. And to qualify for a Pell Grant, a student must demonstrate financial need through the free application for Federal Student Aid Form, or the FAFSA, which we'll hear more about later. The maximum federal Pell Grant for the 22 to 23 award year is $6,895. I'm now going to turn it over to my colleague, Dr. Belinda Wheeler, who's going to talk about steps for launching a prison education program.
Great. Thank you so much, Margaret. From the timeline, you can see that this has been an incredible journey that has brought us to where we are today. On October 27th of this year, the final regulations were released, and now we are preparing for Pell reinstatement that begins July 1st of 2023. So how does one become an approved PEP? First, it is important to understand the location, the benefits of expanding the additional location definition for PEPs, and who is eligible to be a part of a PEP. PEPs include more than just prisons. The definition of an additional location, which was released as part of the final regulations, include federal, state, or local penitentiaries, prisons, jails, reformatories, work farms, juvenile justice facilities, or other similar correctional institutions. The benefits of expanding the additional location definition are critically important for students because they're provided additional quality measures, including oversight by college accreditors, and federal government protections, including Pell Grant restoration should a PEP cease operations. It's also important to note that any person who is incarcerated, regardless of sentence length or conviction type, is eligible to be a part of a PEP. The final regulations provide colleges with various options moving forward. For new or existing non-second chance Pell colleges that wish to become an eligible PEP, they will be required to follow the October 27th regulations. For existing second chance Pell sites that do not wish to transition to an approved PEP, their program will end in one of three ways, with the earliest applying. July 1st of 2029, a student completes their credential, or the date a student exhausts their Pell Grant. For existing second chance Pell colleges that wish to transition to an approved PEP, the regulations state that they will follow forthcoming sub-regulatory language. We expect to hear from the department, more from the department in due course. Determining eligible PEPs moving forward is a critical part of the Pell reinstatement. The PEP pre-approval process is clear. First, colleges must speak with corrections and complete any application they create to vet a potential college partner. Second, the college connects with their accreditor and completes any processes required by them. And third, the college reaches out to the Department of Education to complete their application. While the department's application is forthcoming, colleges can start the process with corrections and their accreditor now. The final approval process is also clear. Assuming the college is approved by the Department of Education, they then start their programming, collecting required data for the department, and completing their accreditation site visit. At the end of the first 2 years, the oversight entity, which in this case is the correctional facility, with input from relevant stakeholders, completes an assessment of the program and determines final approval for the PEP. As I've noted in the two previous slides, institutional accreditors will play an important role in ensuring quality programming for students who are incarcerated. This will include an evaluation by accreditors of at least the first PEP offered at the first two locations, regardless of the correctional facility's proximity to the college campus or method of delivery. Site visits by accreditors will occur as practicable, but no later than 1 year after initiating the PEP at the first two additional locations. It is also important to note that education modality does not determine whether a site visit by the accreditor takes place. Even if your program is 100% online or correspondence, your program must go through the substantive change additional location paperwork and site visit with your accreditor. Off-cycle visits by accreditors may also be needed. In the case of current second chance Pell colleges that recently went through the substantive change additional location process, which included a site visit, a visit to the now defined PEP will need to be completed within 1 year of initiating that PEP program. Colleges are encouraged to speak with their accreditor to receive guidance. A critically important part of any application that a college makes to a correctional facility, accreditor, and the Department of Education will be the best interests of students criteria. Any approved PEP must show evidence of the following. The first three, according to the regulations, comparable experience, credentials, and turnover of faculty, transferability of credits, and comparable academic and career advising while incarcerated and in advance of re-entry, must be substantially similar to those at other similar programs at the institution, accounting for the unique geographic and other constraints of prison education programs. And the fourth must under the best interest of students criteria is the ability for students to continue their education at any location of the college post-release. We note that this may require colleges to modify their application process. Another possible consideration for any application to corrections, the college accreditor, or the Department of Education could include outcome indicators such as the following: recidivism, job placement rates, earnings for graduates, continued enrollment after release, rates of completion, or other criteria as determined by the oversight entity. Any approved PEP will also have to abide by the government's waiver criteria. For approved PEPs that wish to expand programming beyond their initial student allotment, there is a scaffolded approval process that includes a 5-year review period. The only exception to the waiver are colleges that are 100% behind bars, such as Ingram State Technical College in Alabama. Note, if you are a current Second Chance Pell College that has an existing waiver from the department, be on the lookout for guidance from them about your potential transition process. Data is also a critically important part of any PEP. That data must be shared with the Department of Education for mandatory reporting they must make to Congress. We expect the department to provide guidance on what data colleges must provide. One data requirement that corrections must provide to their college partner is the date a student is transferred or released. That data must be provided to colleges within a reasonable time frame so colleges and students can plan accordingly. PEPs do not happen in a vacuum. Students enrolled in a PEP have needs beyond the college classroom. The final regulations explain possible roles for an optional advisory committee and the mandatory requirement of having relevant stakeholders providing feedback to corrections throughout the application and review process. If you are a college or correctional agency that has yet to engage with the wider community, now is the time to have those conversations so you can help ensure that students have broader support while taking classes inside or outside prison. As part of Vera's work, we are helping engage and/or create statewide consortia. Later this month, we will be hosting a webinar on the subject, and we will have various stakeholders, including people who are formerly incarcerated. At the end of today's webinar, we will provide additional information. There are a lot of different stakeholders on this call that have unique questions about next steps. What we have done is create some slides with a summary of what we have essentially presented already in a step-by-step format. For colleges, for example, we recommend that they review final regulations to plan how your institution will establish an approved PEP. And for Second Chance Pell colleges, start reviewing the forthcoming sub-regulatory language from the Department of Ed as it becomes available. Assess how your college's proposed PEP will meet the best interests of students criteria and ensure buy-in across your institution. Establish or renew relationships with community-based partners. Seek out or start a statewide consortium that includes diverse stakeholders. Meet with your current and/or new correctional partners to discuss updating or creating new agreements that clearly detail each party's responsibilities. And meet with your institutional accreditor to discuss additional location requirements. For corrections moving forward, we ask that you consider reviewing the final regulations and upcoming sub-regulatory guidance from the department and determine what changes your facility or state will need to make. Review your current process for evaluating college and prison programs and consider updating that process so that current or prospective college partners are meeting the required best interests of student criteria. Seek out or start a statewide consortium that includes diverse stakeholders, and meet with your current college partners to discuss updating or creating new agreements that clearly detail each party's responsibilities. Now I'm going to turn it over to my colleague, Alan, to share information about financial aid.
Thanks, Belinda. So first, I just want to share a few pieces of general information about financial aid for folks who are a little bit newer to this. Expenses. Incarcerated students are able to utilize their Pell Grants for tuition, fees, books, supplies, and any applicable licensure fees associated with their earned credential. This is unlike students in the community who can also pay for things like room and board and any other education-related expenses. Credit balances or refunds do not exist for incarcerated students. Since the cost of attendance is calculated to only include the expenses I've named, financial aid award packages are structured to ensure that students do not receive a refund in the same way they would in the community had room and board and other expenses been included. It's also worth pointing out that this funding all stays with the college. Payments for tuition, etc., are applied directly to the student's bill, eliminating the need to exchange for money to exchange hands with the college to the student and back to the college again. General eligibility for Pell Grant requires an applicant to be a U.S. citizen or eligible non-citizen, have not earned previously a bachelor's degree or other professional degree, show qualification to obtain a college education, demonstrate financial need, and not have federal student loans in default. So the next slide, I want to talk about some common challenges. Throughout the 6 years of the experiment, some of the challenges we've seen come up have been resolved, like selective service requirements being eliminated and restrictions for people with prior drug convictions being lifted. Others will soon be resolved, or we've also learned some lessons that can be helpful that I'll share now. Defaulted loans are perhaps the biggest one. I'll go into the temporary solutions momentarily, but I do want to say that if you've come here today hoping to hear more about how the debt relief program can benefit incarcerated borrowers, we do not have any new information. Unfortunately, the Department of Education is no longer accepting applications for debt relief due to pending litigation, but they have stated on the website that any applications they have already received will be held until the litigation is resolved. Obtaining financial information is a challenge, particularly from parents, which I'll talk about in a few minutes. Married students also have to include their spouse's information, so they will need to have that on hand or be able to obtain that information. Some colleges have helped students track down this information after having a FERPA waiver signed. I do want to mention that Social Security numbers must match the name, and sometimes people are serving time in prison under a different name, which causes a lot of issues for financial aid. The only way to get federal aid is to apply under the correct name that matches the Social Security number. If the person is incarcerated under the wrong name, that is something the college, the student, and the corrections partner will have to work together to resolve. Generally, verification of identity has also been a challenge. However, ED does allow prison ID to be used as an acceptable form of identification as long as the student is incarcerated. Verification of high school equivalency can also be a challenge. Many colleges have struggled finding transcripts, particularly from out-of-state schools. Another issue is paying for the transcripts through services such as Parchment or Diploma Center. Colleges have been known to set aside special funding for this purpose when that has presented repeated challenges for them. However, an unofficial document from the corrections partner is also an acceptable form for financial aid purposes, so that might be a helpful consideration. Finally, completing the FAFSA itself is challenging, particularly without internet. Most students in prison are doing this the old-fashioned way with ink pen on paper. Usually the colleges are there in some capacity and assist students with the completion or provide detailed instructions. They then collect the completed forms to be returned to ED, or their financial aid office enters the information manually into ED's central processing system. Many colleges opt for this method since they can catch any mistakes in advance and for faster processing. However, some colleges and corrections partners have figured out how to allow the completion of FAFSAs over the internet by whitelisting the FSA website. This can be preferable because a lot more guidance is provided to the student automatically. The catch is that students need access to an FSA ID, which requires an email address. Some schools have found a way to route email addresses in a way that students can still get access to the information they need. The other option when completing a FAFSA online is to print signature pages for the students to complete and then file for the records. So going back to loan defaults, which I think is the next slide. People with federal student loans in default are not eligible for student aid. There's a process called loan rehabilitation, which requires a borrower to complete 9 monthly $5 payments on time. Setting this up is difficult because they have to contact their loan servicer and aren't always able to do so. And the funding and processing the funding on time has also been a challenge. The good news for now is that we have a program called Fresh Start that essentially allows a borrower to skip this loan rehabilitation process and apply for aid automatically and have their loans put in good standing. However, it requires action on the part of the borrower. So colleges need to be proactive, reaching out to students. If you already have a current FAFSA on file for your student who's in default, your financial aid office can go through and check to see if the defaulted loans qualify, reach out to the student to have them sign a statement agreeing for their loans to be transferred to the correct loan servicer, which is only required if they defaulted before the pandemic pause, document their eligibility, enroll the student and draw down Pell. If there isn't a current FAFSA on file, the student would need to submit one to trigger this process. One thing to note when using the Fresh Start process is that unless a student is enrolled half-time or more, they would be required to begin repayment. If that is the case, income-driven repayments may be an option, but that does require the student borrower to fill out paperwork and return it to the loan servicer, and it may necessitate assistance from the college to do so. Well, for those students enrolling in half-time or more, their loans would be placed in school deferment, so the process should be relatively simple. The process for borrowers who do not plan to enroll in school but would like to begin repayment in good standing is less clear to us at this time, and we hope to get more information to be able to help those borrowers as well at some point. If your institution is worried about how this could impact your default rates, should any of these students fall back into default, Ed has assured us that this is not the case. This option is valid until December 31st, 2023. So make sure and get those defaulted students enrolled as soon as possible. So on this next slide, I want to make a plea to corrections officials and ask colleges to push their corrections officials on this. People in prison have a very few ways of communicating with anyone, particularly when it comes to managing debt. Many states block, state departments of corrections block incarcerated students from making phone calls to toll-free numbers such as those listed here. My suggestion is that you work to include these numbers listed here on the phone system allowed list. The numbers to the left are for general information from the U.S. Department of Education, as well as their default resolution group. The numbers on the right are a current list of loan service providers who may be servicing loans people in custody are holding. You can ensure these numbers are allowed. It would go a long way towards helping incarcerated people manage their student debt. And as we mentioned in the chat already, we will be sharing these slides. So those numbers, you don't have to worry about capturing those now. You'll be able to get them. So in this next slide, I just wanted to talk briefly about verifications. This is a way that the federal government protects taxpayers against fraud. People are randomly selected for verification when applying for federal student aid. There are currently 3 types of verifications, and they're listed here. But this does require the college to go back to the students and collect this information, and has been a challenge in the past. On the next slide, I'll go over a few updates pertaining to verifications, which are welcome news. Due to the pandemic, Ed has issued waivers to certain verifications, including for income and high school equivalency. This is currently in place for all students across the country. For the 23-24 financial aid year, this waiver will remain in place for incarcerated students. This is very good news for financial aid offices who have typically struggled to help students track down these documents. Now, you may be asking, how will the Department of Education know if a student is incarcerated? Which is a good question. They will know this through one of three ways. One is a manual indicator colleges can use in the central processing system. Another is the incarcerated student FAFSA, which I'll show you on the next screen. And the third is through address matches. So here, I just wanted to show you an example of the incarcerated student applicant form. It's actually not very different from the regular FAFSA, except that it does have an indicator at the top that it's an incarcerated applicant form. It does allow for the use of dark ink, where the regular FAFSA used to say black ink only, which presents an issue in some carceral settings. And then there is a different PO box where these will be processed through a different, processed differently. So now I want to just say a little bit about dependency overrides. This goes back earlier to the issue of needing to get parental tax information. So step 3 on the FAFSA asks a series of questions to determine if a student is dependent upon a parent financially, such as if the student is under 24, has served in the military, has been a foster child, is homeless, etc. Except under unusual circumstances, financial aid offices must gather income information from parents of dependent students, which has often been challenging for incarcerated students. Financial aid offices are granted authority to exercise professional judgment to offer dependency overrides when they can document unusual circumstances. The FAFSA Simplification Act makes it clear that incarceration of a student or the parent of the student is an unusual circumstance that, once documented, allows for a dependency override to be granted, negating the need to track down parents and get their tax information for the FAFSA. So now I want to pass it back to my colleague Margaret, who is going to share some resources with you.
Great, thank you so much, Alan. For those of you who are really dying for more detail on all of these financial aid provisions, we wanted to flag that the Federal Student Aid Virtual Conference is happening later this month. It is free to register, and there is a session on November 30th specifically about prison education programs that we would encourage you to check out. It might be good to share with financial aid staff at your college or others who are trying to sort of get their minds around the financial aid aspects of this. And for those of you who are later in joining us, we'll be sending out this recording and the slides. You'll have all these links. Another resource we wanted to flag on the Federal Student Aid Knowledge Center, there's a prison education program topic page. So this is a place where more information will be posted about Dear Colleague letters. You can find the final Pell regulations. The FAFSA for incarcerated students is there. And the Department of Education has also created this new email address for prison education program related questions. So that's pep@ed.gov. Belinda referenced this earlier, but as you're thinking about how your jurisdiction is going to be engaging relevant stakeholders in vetting interested prison education programs, we wanted to invite you to a webinar that we'll be hosting later this month to learn more information about existing models from other jurisdictions and what might work for you. There's a lot of information out there. So we wanted to just flag a couple other resources. The Alliance for Higher Education in Prison is a place to see where some of these programs are happening. It's a great network to get connected to. They host conferences annually There's also a really interesting resource bank where you can see some materials that various college and prison programs have created. The Formerly Incarcerated College Graduates Network is another great resource to connect with directly impacted leaders, thinking about how to diversify your stakeholder groups as you're developing these programs, and thinking about getting input from a range of stakeholders, including people with lived experience. We've written a couple of reports that I wanted to flag, both summarizing data from Second Chance Pell. We have a guide on starting new programs and engaging stakeholders early in that process. There's some information about state financial aid and where those policies allow incarcerated students to access state aid, as well as a very recent resource that we developed with the Higher Learning Commission, really designed for college accreditors. So again, these links will be shared with you after the event today. So I want to thank you again for sending in so many great questions in advance of the webinar. And please feel free to keep dropping them in the chat. We are monitoring those. But I'm going to invite our colleagues from the Department of Education to join us, and we'll dive into some of your questions. So we've gotten some questions about eligibility for these programs. Are there any statutory limits on who can be part of a prison education program?
Yeah, that's a great question. There are no Department of Education restrictions on student convictions or sentences for participation in the prison education programs at all. So the statute is pretty clear on that. There are no provisions.
Great, thanks, Michael. And do you mind introducing
Oh
yourself?
yeah,
briefly?
I'm Michael Cagle with the U.S. Department of Education. Happy to be here today.
Thank you.
And I have a video, I guess, too. I guess I can turn that on.
Great. Will incarcerated students who are enrolled in a 4-course undergraduate certificate program be eligible for Pell?
So I'll jump in here. Hi, everyone. My name is David Musser. I'm the Acting Deputy Director for Policy Implementation and Oversight at Federal Student Aid at the Department of Education. And the answer to that is it depends. There's no restrictions on eligibility for prison education programs, for example, to certificate programs or programs that don't lead to a degree. All of those types of programs could potentially qualify, as long as they meet the department's general requirements for program eligibility. Now, I want to be clear, the general requirements for program eligibility include minimum length restrictions. So if you want your program to qualify for Pell Grants, generally it has to be at least 15 weeks in length, and it has to include at least 600 clock hours, 17 semester hours, or 24 quarter hours. There are some exceptions for programs that require an associate's degree as a prerequisite for admission, but generally speaking, those are the shortest programs that you can qualify for Pell for.
Thanks, David. So I know more is coming in terms of the sub-regulatory guidance for the Second Chance Pell schools, but we have a question on the transition for Second Chance Pell schools to Pell reinstatement and the prison education program process. Will Pell Grant implementation essentially replace Second Chance Pell?
Another very good question. The department does plan to provide more information to the public about the transition of Second Chance Pell. The experiment itself, we plan on providing more information in the very near future about that. Second Chance Pell participants should expect to receive more information from the department in regards to, and the experimental sites team in general, in regards to that transition process. So stay tuned for that. It is forthcoming.
Okay. And do you have any recommendations in terms of steps that Second Chance Pell schools need to take to add more facilities?
The current Second Chance Pell schools can add more facilities using the process in place right now. Under the experiment, that can continue throughout. We'll provide more information in the transition, but yes, they can continue to add correctional facilities, just like they do now. So.
Great. And then we had a question about, can you apply Pell for courses or just for programs?
And I'll cover this one. You can't apply for Pell Grants for single courses. In order to qualify for Pell Grants, a confined or incarcerated individual needs to be enrolled in an eligible an eligible prison education program. And that's true really of all Department of Education eligibility requirements. You have to be approved to have a full program. We don't approve individual courses.
Okay. So we've been asking some questions that are kind of more focused on the college side of things. Switching to the correction side or the oversight entities side of things, what specifically are corrections responsibilities as the oversight entity? And can you talk a little bit about the process of how an oversight entity kind of gets started?
Sure. The oversight entity, the responsibilities of the oversight entity are actually outlined in the regulation. So as you pointed out during the webinar here today, it's important for you to take a close look at those regulations because they do provide some helpful information in regards to what the role of that entity is. But important, one of the main responsibilities up front of the oversight entity is to approve the PEP to operate within the correctional facility environment. So it has to be approved to operate at the correctional facility itself. And the oversight entity does have the responsibility to ensure that the program is operating in the best interest of students. And the department will provide more information in our sub-regulatory guidance about the actual role of the oversight entity. But I think the most important thing to know now is just that entity itself is going to be responsible for approving the program to operate in the facility. And that's the first step. But again, stay tuned for more information because that will be forthcoming. We do plan on providing some more sub-regulatory guidance in regards to various topics, including the oversight entity.
Okay. One of the really important constituencies that are eager to learn more about these regulations and what they mean for them are people who are incarcerated. Will the department be making documents available really geared towards people who are incarcerated to understand what these regulations mean for them?
I don't know if Ashley, are you on the line? I think that's a good question for you. She may be having technical difficulties. Oh, there she is. You're still on mute.
Hold on. Yes, so I am right here. Margaret, do you mind re-answering that question for me?
No problem.
I froze a little bit. I'm sorry.
You're fine. So people who are incarcerated are certainly a very interested group in terms of better understanding these regulations and what it means for them. Can we expect some information from the Department of Education for people who are incarcerated to help explain these regulations?
Oh, absolutely. Yes. Schools should continue to watch FSA's Knowledge Center website, which will provide more detailed information about the requirements to offer offer requirements for Pell Grants to confined or incarcerated individuals. We also recommend reaching out to your accrediting agency or to facilities that you would like to work with to learn more about what you need to get started.
Great, thanks, Ashley. Okay, this is a college-specific question. Do I need to add the facilities as additional sites to our e-app?
That's another very good question. And so basically the requirements for additional locations when it comes to adding facilities does not change in under the new provisions. So any correctional facility would be subject to those requirements that we have for additional locations. So yes, they would need to be reported as additional locations and go through that process on our electronic application when the school applies for the prison education program.
And I just want to add one thing to that. One of the important things to remember is some schools, distance education and other kinds of education where there aren't instructors at the facility are not as common in a correctional environment, but there are some programs that we're aware of that are out there. And if you, as an institution, want to offer an eligible prison education program through distance education or correspondence, you would need to add the facility where you're offering the program as an additional location. That's a specific requirement in the new regulations, and it's something that we want everyone to remember as they're considering how they might, what modalities they might want to offer their programs through.
Thank you. I think we covered this a little bit in the slide, but just to make sure everyone has this information. If a student previously lost a Pell Grant and has corresponding debt, would they be able to benefit from Fresh Start?
So I'm not exactly sure what the question is getting at. Anyone who has defaulted loan debts, defaulted federal loans prior to the beginning of the pandemic is eligible for Fresh Start, and as long as their loans are eligible in general. So if that's the case, then yes, Fresh Start will help pull the individual out of default during the period that Fresh Start is active. And if the school follows the requirements to have the student enroll and submit the signed statement, et cetera, then once they receive additional aid, then they'll essentially Fresh Start will become permanent for them and they'll be out of default moving forward.
Okay.
David, I think the question was specific to Pell overpayments and how those are handled, and can they be handled under Fresh Start?
Got it. Fresh Start does not cover Pell overpayments. They're really, that effort is focused on defaulted loans and not overpayments. The department does recognize that those have been identified as challenges for some individuals, but they're not covered under the Fresh Start initiative.
Okay. Here's a question on the incarcerated student FAFSA. Is there a new comment code for students completing the incarcerated student FAFSA?
I don't believe there is a new comment code, and my colleagues can correct me if I'm wrong, but I do believe that the incarcerated student FAFSA is very much identical to the other FAFSA that all students use, but it just has the incarcerated individual indicator. So when a student actually applies, we will be able to log that the student is incarcerated as well. And then there's also an address that it goes to specifically that will be able to process that application for an incarcerated individual. There's also, I think, as was covered in the session today, there's also a process that a school can manually indicate that the student is incarcerated. And then we have an incarcerated student indicator in our systems as well that can be set for students. But that FAFSA itself is marked as incarcerated, and when a student actually completes that FAFSA and mails it to that address, the student will be marked as an incarcerated individual.
That's absolutely right, Michael. And in those three ways that Alan spoke about, those are the three ways to identify a student that is incarcerated from the FAFSA.
Great. And I love that those of you who know this really well in the chat are sharing information with each other. That's excellent. There's a lot of expertise in this Zoom room for sure. And for people who had filled out a FAFSA with incarcerated students and did not use the incarcerated student FAFSA, that's not an issue, just to clarify. It's just that there is now this additional option. Is that correct?
That is correct.
Okay.
So I see in the chat that someone was concerned about the FAFSAs that were sent that didn't have that weren't the incarcerated student FAFSA. It's important to note that there are various ways that an individual can be identified as incarcerated, that those individuals may be flagged as incarcerated, but it is the school's responsibility to ensure that ultimately the incarcerated student indicator is flagged for the individual if they don't use if the student doesn't use the incarcerated student FAFSA. And part of the reason that's important is that the department waived the verification requirements for the 23-24 award year, and the requirement to qualify for the waiver is that the individual has the flag for incarceration status. So it's really important for your audit, for audit purposes, et cetera, to be sure that if you don't perform verification, if an individual happens to be selected, that they have the incarcerated student indicator. So it's important for a variety of reasons to ensure that that's correct in CPS.
Can I just jump in and related to that? It is important to remove the flag as well for folks, not just for the reasons already indicated, but also because award packages will be different. So once a student is not incarcerated anymore and attends school on campus, they would then qualify for those additional expenses and such, like housing, room and board, and things like that. So the student needs to make sure, and the financial aid office needs to make sure they work together to ensure they're getting the right benefits they're entitled to.
Thanks, Alan. So we've got a couple people participating who are clearly planning ahead, which is great. So we have one question about, could a state university system become a prison education program system-wide, so that each college in the system can participate?
The answer is that depends. Again, it depends on how the state system is structured in the department's system in the EAP. Some states have designed their state systems such that it's one single institution with one 6-digit OPE ID. That's the designator for the institution. In that case, the school could absolutely set up prison education programs. Now, remember that prison education programs are location specific. So you have to ensure that if you're offering it at multiple facilities, that you have multiple locations added for those specific facilities. But in that case, it is a single institution that's submitting an application for a program that could apply across multiple campuses if multiple campuses want to offer courses at that particular facility. But we know that most states do not structure their state systems that way. So in most cases, each institution within a state system has its own 6-digit OPE ID. And in those cases, those have a legal status as their own institution and will generally need to apply separately to offer prison education programs and add additional locations.
Okay, great. We have a question about the timing of kind of accreditation approval. So if a college already has approval from a corrections department and its accreditor, are they eligible already for the Department of Education to approve them as a PEP, or how should they be thinking about the timing and sequence?
So that's a great question. And I think I would say, if you have approval from your accrediting agency and the facility, and you have a separate funding source, you could begin offering education in the setting. Nothing prevents you from doing that. The program won't be eligible for Pell until you have what we call an eligible prison education program that has gone through the whole departmental process. So important to remember is that the first prison education program at the first two facilities where you offer prison education programs will need to go through a full approval process with the department. And until you go through that approval process, those programs are not eligible for Title IV aid and for Pell grants. So you need to be sure that you go through that process in order to actually provide Pell grants to students. Also keep in mind that the program may otherwise qualify, but the first time that students can qualify under the new statutory and regulatory provisions is July 1st, 2023. So there is a little bit of time to wait. The department's working right now on developing guidance and procedures for how you'll submit the information to the department for your application. It sounds like that particular institution might be one of the first that's ready to go, which is great. But we're working on getting that prepared and out to schools as quickly as possible prior to July 1st, 2023.
Okay, great. So let's shift our focus a little bit to jails, which is a different context from prisons. And we have a question about the program at the jail. So students may be there for a shorter period of time, and it might cause some complications around what types of programs college could offer. Would a college have to offer a full degree program in the jail to be a PEP, even if students might only complete some courses pre-release?
This is a very interesting and complicated question. So the first thing I would say is that many times in jails, the individuals being confined have not been sentenced. So in those cases, those individuals do not meet the statutory definition of a confined or incarcerated individual. And so they're eligible for the full suite of Title IV assistance. Now, if they have been, and this does happen as well, in some cases, jails are also a place where individuals have been sentenced and are confined while sentenced. In that case, in order to provide Pell Grants to the individual, they would need to be in an eligible prison education program, and you would need to have that program approved. But it's really important to understand the individual's conviction status before you make a determination about what they'll qualify for or what's necessary to provide them with Title IV assistance. If, for example, you're offering correspondence or distance education or in-person education in a jail setting to individuals who have not been sentenced, those individuals are eligible for all Title IV aid, assuming they meet other eligibility requirements, and you should consider them for all of those types of aid.
This is complicated, David. Okay. So we've got a couple of questions around correspondence courses. Are correspondence courses, would those be eligible for Pell? And how do we think about correspondence in the framework of a prison education program?
Yeah, that's an important question. As we all know, correspondence courses are a traditional way that confined or incarcerated individuals have engaged in post-secondary education and continue to. And that doesn't change with the introduction of the new prison education program requirements. However, the statute does not prevent students from receiving Pell Grants if they're in correspondence courses. So if that's the way that you offer courses to students in carceral settings, you can do that. However, as I mentioned before, in order to qualify for Pell as of July 1st, 2023, you need to ensure that you have an eligible prison education program at that facility where you're offering correspondence courses in order for the students there to qualify for Pell. So it's not as simple as you offer the correspondence courses, the individual reaches out and finds you, and you can simply offer it to one individual at the facility without going through the full approval process. These programs, like distance ed programs and like programs where there's on-site instruction, all require that you actually have approval as an eligible prison education program at that particular facility, and that you add the facility as an additional location, assuming the student can complete at least half their program there.
Okay. When students are released and are out in the community, would you recommend that they resubmit the FAFSA in order to remove the incarcerated student flag? Or is there a different mechanism to do that?
So there's different ways that it could be done. One of the things that probably there's, I guess I would say, if the institution if they're attending the same institution, I would recommend that the individual reach out to the financial aid administrator there to request that they remove the flag. That's probably the quickest and most effective way of doing it. Each institution has the ability to switch that flag on and off in FAA Access. And that's the I would say the cleanest way of doing it. If the individual submits a traditional FAFSA online, I think we need to go back and look to see what happens in our systems.
I can help you with this one, David.
Great, go ahead, Kira.
Once you have a FAFSA in the system for the same award year, you cannot submit a second FAFSA, right? So the student can submit a correction to their FAFSA, but it's not the student side that's setting their incarcerated student flag, right? So if you are a second school, so like David was saying, the same school, if the student moves from being within the prison educational program within the correctional facility to being on your brick and mortar campus or your online class campus or just not in your prison educational program, the same school can submit a correction to that ISAR to remove the incarcerated student flag. If you are a new school, I'm assuming that you're already telling the student that they need to make a correction to add your school code. Once you get a copy of the new transaction that's generated from adding your school code, you should be able to remove the incarcerated student flag. But to reiterate, once any student has a FAFSA on file for an award year, you cannot submit a second FAFSA. FAFSA is going to push you to make a correction.
Yeah, it's a good point. The other thing that I would say is that institutions need to keep an eye on that comment code. I believe someone in the chat indicated that it was comment code 406 that indicates that the individual has the incarcerated flag. And if you know that the individual is not incarcerated, the school needs to take action to remove that flag. Alan mentioned that before. It's a really important part of the process because that could cause challenges in your system, in audit for audit purposes, et cetera. You want to be sure that that gets unflagged.
Okay. So thinking about sort of another issue related to people releasing to the community, what's the responsibility of the prison education program to ensure transferability of credits to another college in the state where that person would be releasing?
So there's a general requirement for eligible prison education programs to ensure that credits in the program transfer to another public or nonprofit institution in the same state. So you as an institution need to make sure that you have, it could be an articulation agreement, it could be some other agreement under a different name that is essentially what we think of as an articulation agreement, but some assurance that the credits from the program will transfer somewhere else. And that's one of the conditions that you'll have to meet in order to become an eligible, to have a eligible prison education program that the department will be looking for during the application process.
Thank you. Belinda, I'm wondering, I want to raise this question to you. This was one that came in about students transitioning out into the community. How can colleges think about helping students transition onto their campus post-incarceration?
Yeah, sure. That's a great question. We have seen with our technical assistance that we have given to the 200 plus colleges that colleges have been doing great creating re-entry navigators for students as they're transitioning. And we've seen a number of colleges, for example, Lee College in Texas, supporting, let's see here, successfully employ former students who were incarcerated to serve as those reentry specialists. We've also seen underground scholars on some of the University of California campuses as well. So there's a lot of great examples already of how colleges are really working well and receiving, fantastic feedback from people that were students in the system and are helping students transition. There's also community-based community-based partners as well. Often a number of them are led by people who have been adversely impacted by the criminal justice system in the past, that also have provided great feedback and support for people as they are transitioning back into a traditional college campus setting.
Great, and thank you, Jasmine, for flagging the other student groups in California. There's a lot of great examples throughout the state for sure. Alan, I wanted to raise one question with you. We had a question around communicating the sort of the financial aid award with students. Do you have any recommendations about how programs think about that piece of this work?
Yeah, so on the FAFSA itself, as students fill out their address, which would be the facility address, many colleges have found it useful to also include their state ID number, so that when students receive mail back through the Department of Corrections, they would actually receive it because their state ID number has been indicated there. We have heard some cases where the student aid reports are not getting through mailrooms, and colleges have opted to instead offer the college address as a place for the student to use on the FAFSA. The student aid report would then end up at the college's address, and then they take those student aid reports physically to the student to make sure that they have the information.
Great, thank you. And yeah, I just want to lift up something Tressa put in the chat too about educational opportunity centers are for sure another great resource to think about supporting students on campus post-release and the TRIO programs, but also we're seeing some folks going into prisons and helping students or prospective students complete the FAFSA in prison, utilizing those resources. So that's a great one to flag. We are heading towards the end of our time together, and I just want to just a couple quick reminders. One, that pep@ed.gov email address is a place to ask additional questions, or some of you had really specific questions about your jurisdiction, so that's definitely a resource for you. We'll be sharing this recording and the slides, which have all the links to the resources. So you'll have that in your inboxes soon as well. And I just want to thank you all so much for your interest, for your great questions, for being resources to one another. And we're really excited to watch the implementation of this new law, which I know so many of you were involved in helping make happen. So thank you all so much. Have a great rest of your day, and please let us know if we can be helpful in your continued efforts.